Hello students. Today we are going to study about the Employees Compensation Act 1923. This is a part of your subject, the Industrial Law BBA N505. So in this topic we are going to study about compensation. So this act was known as Workmen's Compensation Act 1923. But in 2009, this act was amended and now it is called as the Employees Compensation Act 2009. In place of the term workmen or the workman, it has been now replaced with the term employee. The objective of the act is to provide workmen or the employees and their dependents some relief or compensation in case of accidents which are arising out during the course of employment. What do we understand by the term during the course of employment? This means that any person who is working in the factory premises, if he or she meets with an accident during that duration while he or she is working in the factory, in that case, that worker would be liable for compensation which has to be paid by the employer. Then there may be certain other situations wherein a worker may contract any kind of disease because of the nature of employment. For example, there are a lot of people who are working in cold storages. So cold storages, we know the inside temperature is extremely cold, whereas outside it may be extremely hot if we are working during the summer crop season. So the workers are required to carry load of material from outside, from the trucks which are parked outside, and they are required to bring in inside the cold storage where the temperatures are really low. So because of the continuous and the frequent change in temperature, a worker can fall sick, he can have pneumonia, he can have any kind of lung infections. So because of which he may be crippled for a longer duration, his capacity to earn, his ability to work is reduced as an outcome. So in order to preserve the rights of the worker, that some relief is provided to the worker for the time for which he is absent from his work. So that is the purpose of the Workmen's Compensation Act. If a worker is missing from duty because of any injury which happened during the accident in the factory premises and the worker is not able to report to work as an outcome, in that case compensation would be paid so that the worker can easily run his family. Then apart from this, there may be certain situations in which the death of the employee may also occur. So under these situations, why only death? There may be situations when there is permanent disablement. The body of the worker is permanently disabled for life. In that case, the employer has to provide compensation to his dependents. So dependents, we'll be discussing about the various definitions under the Act. So then that is when we are going to discuss about what a dependent means. If we talk about the scope and coverage of the Act, so this Act applies to whole of India. It applies to all the employees who are working in factories, in mines, plantations, railways, construction sites, ships, circuses, and even restaurants and hotels. So all these employees are covered under the purview of this Act, but it does not apply to people of the armed forces who are covered, and also to the people who are covered under the ESI Act. ESI Act means the Employees State Insurance Act 1948. So if employees are covered under that particular act, in that case the Compensation Act would not be applicable. And like I earlier mentioned, it is not applicable on the armed forces. So the section 2 of the Act has given a lot of definitions. So you can see on the board the definitions are as given under the Act. The first one is the definition of a commissioner. So commissioner here means a person who is appointed for the purpose of this Act. So the role or the duty of a commissioner is that whatever compensation amount that the employer has to pay, that is deposited with the commissioner and then it is disbursed to the employees. And then commissioner also looks at the various review applications or claims which have been made by the employees. The second definition is about the compensation. So compensation here means any monetary benefit that an employee is going to get because of the nature of injury or because of any kind of accident which has taken place. So this has been given under the section 2 of the Act. Now the wage calculation, earlier the wages up to 8,000 were taken into consideration for calculation of compensation amount. But from January 3, 2020, these wages have been revised, and now minimum 15,000 wages are taken into consideration for calculation of compensation here. Now compensation under this Act is not same as compensation which is given for any kind of civil wrong. So that compensation is different. Here this is compensation is meant only for the purpose of this particular Act. So next definition is the dependent. So dependent means any person who is dependent on the salary or on the wages of a deceased workman, or he or she may be a relative of or the relatives of that particular workman. So under this situation, anybody, the widow of an employee would be a dependent. Any minor legitimate or adopted son would be there. If the parents of that employee are dependent on him, in that case those parents would be there. Any unmarried daughter or a widowed daughter who is living with the parents, in that case that female would also be dependent on the earnings of the employee. Now, so basically anybody who is wholly or partially dependent on the earnings of the employee would be called as a dependent. Now apart from this, there are many other people who may be dependent, a minor brother or an unmarried sister or a widowed sister, a widowed daughter-in-law. So all these would come under the category of dependent. Next definition is employee. I'm sorry, I have written employee at the bottom. So employee here means a railway servant, as in clause 34 of the Railways Act 1989, who is not permanently employed in any administrative or subdivisional office of a railway. So the catchword here is that the person should not be permanently employed somewhere. He should be a daily wage earner or a laborer who is getting wages on a weekly, fortnightly or a monthly basis. So that person would be called as an employee here. This employee definition shall also include a master, a seaman, or other members of the crew of an aircraft, or the captain of a ship, a person who may be recruited as a driver, as a helper, as a mechanic, as a cleaner, in connection with any motor vehicle. A person who is recruited for work abroad by a company, even that would come under the definition of an employee. Any person who is employed in any such capacity which is specified in Schedule 2 of this particular Act. So this Schedule 2 of the Act specifies a lot of professions or the occupations which are, if people are performing those duties, then they would be called as the employees in those particular factory. The definition of an employer here, the definition of an employer, it means any body of persons, whether incorporated or not. He or she may be any managing agent of an employer and the legal representative of a deceased employer. Say for instance, when Dhirubhai Ambani passed away, his son Mukesh Ambani and Anil Ambani, they were the legal heirs for his company. So they were the legal representatives and legally they were the heirs of the company. So the businesses were equally distributed between the two brothers. A managing agent may be a person or any company who is acting as the representative of another person for carrying out the trade or business. So we can understand this with the help of an example also. For instance, when you are in colleges and you go for placements, so the placement company, say for example Hindustan Unilever, so that company, if they are coming for campus placements, so what they can do is either they send their own people from the HR for the campus placement drive, or they may hire a third party which may be called as a recruitment process outsourcing firm, or maybe any other HR consultancy firm for carrying out this placement drive. So there are two methods of doing this, either directly or the second case is through the HR consultancy firm. So here the HR consultancy firm can be called as a managing agent who is managing the recruitment process for Hindustan Unilever Limited. Then the next definition is minor. So minor is a person who has not attained the age of 18 years, and that person, as per the Factories Act, a child is not allowed to work in the factory premises, but a minor who is below 18 but who is above 14 years of age can work in the factory premises. The next definition is disablement. So disablement means the loss of earning capacity of an employee. So this can occur because of any kind of accident, it can occur because of any kind of injury, or it may be because of any kind of disease that the employee may get during the course of his employment. So this disablement can be partial or it can be total. At the same time, it can be permanent or it can be temporary. So this is how we distribute the two types of disablements. If I talk about partial disablement, so partial disablement is where there is a reduction in the earning capacity of a workman as a result of some accident. So it can be further classified into temporary or permanent. So temporary partial disablement is when a certain body part gets, is affected because of the injury, and as a result the worker is not able to join duty for a specific duration of the time, and when that disease or when that injury is healed, he or she may be able to work with his or her full capacity. So this is called as temporary partial disablement. Then there may be a certain kind of disablement which we call as a permanent partial disablement. For this we can take into consideration an example, a worker who is working in the factory premises, the left hand, say the little finger. So there is an injury to the hand, and as a result, during the course of treatment, some septicemia takes place in the hand, and the little finger has to be cut off because of that infection. So this is a kind of a permanent disablement, but it is partial because it is not going to affect the earning capacity of the employee to a large extent. Right? In spite of his little finger, the employee would be able to devote full time on his employment. So that is permanent partial disablement. Yes, the worker would be liable for compensation because there was injury to his hand and he was off duty for a longer duration. Then we talk about total disablement. Total disablement again could be partial, or it could be temporary or it could be permanent. So total disablement, let us take the example of a partial, the temporary one. So say for instance a worker meets with an accident, he falls down, the floor was slippery and he falls down in the factory premises, injuring his head and injuring his leg. As a result, he was totally disabled for that particular time. He was bedridden for 6 months, and he couldn't, obviously when he was bedridden, he couldn't perform his duties. But then after 6 months, after he fully recovered from that particular injury, he was able to join back duties again. So this is temporary total disablement. A worker was totally disabled, but it was for a temporary period, and then he could join back duties. Second one is permanent total disablement, which means that a person is disabled for his entire life. So there are cases where accidents have happened, there was damage to the nerves or maybe to the spine, and as a result the employee was totally bedridden. He may have slipped into coma or any other reason. So as a result, the worker is totally disabled and he cannot join back duties. So under these situations, his dependents, they are given the total amount of wages, which we would be discussing further in the subsequent part of this video. Wages are again any privileges or benefit which are quantified in monetary terms. Now when we are talking about wages can be paid to the employees on a weekly basis, fortnightly basis, or maybe on a monthly basis. Any kind of traveling allowance which is being given to the employees, that doesn't fall under the category of wages. Similarly, any contribution which is being paid by the employer towards the pension fund or towards the provident fund, even that doesn't qualify as wages. Apart from this, any kind of bonus which is given to the worker or any special expenses being given to the employees, they don't come under the category of wages. Also, the leave which are carried forward to next year's and they may be encashed later on, even they don't form a part of the wages. So to sum up, these were the various definitions that we had discussed. So we spoke about the Employees Compensation Act 1923, which was earlier called as Workmen Compensation Act, but it was in 2009 the act was amended and now it is called as Employees Compensation Act. The other major feature which happened was that in January 2020, the wage calculation for estimating the compensation amount, that has been increased from 8,000 rupees to 15,000 rupees. So as a result, the workers would be benefited a lot. And apart from this, we discussed all the definitions which are given under these Act. So these definitions are really important from the purview of this Act, because on the basis of these definitions only a person would qualify to be a dependent, to be an employee, or to be an employer. So that's it for today. Thank you so much.